Our focus today is the conviction of the suspended Dean of Law at the University of Calabar, Professor Cyril Ndifon. We now know that after about a year and a half of standing trial, a federal high court in Abuja has convicted the suspended law professor at the University of Calabar, popularly known as UNICAL, Cyril Ndifon, of sexual harassment. Now, Justice James Omotosho, in a judgment, held that the prosecution established its case against Ndifon, described as the Dean of Faculty of Law, UNICAL, and sentenced him to 5 years imprisonment without an option of fine. Now, he held that the prosecution was able to prove the ingredients of the offenses in counts 1 and 2. The judge noted that Ndifon was unable to contradict the evidence that he unduly pressured prosecution witness 2, referred to as TKJ, to perform the immoral act with her. Justice Omotosho was of the view that the prosecuting agency, that's the Independent Corrupt Practices and Other Related Offences Commission, ICPC, proved the offenses in counts 1 and 2 beyond reasonable doubt against the first defendant, Ndifon. Well, with Professor Ndifon now sentenced to 5 years in prison after being found guilty of sexually harassing a student and abusing his office. The judgment is regarded as one of the strongest signals yet on academic accountability, power imbalance, and the legal protection of students in Nigeria's universities. But underlying and thought-provoking twists and questions still abound. How stern is this penalty? How many more are in the system undetected or still operating as gods? Now, can the scourge truly be stamped out in Nigerian universities? To help us unpack the legal, ethical, and systemic implications of this ruling, we're joined by our guest, a legal practitioner and constitutional lawyer, of course, who will guide us through the broader significance of this case and the possible paths to light in Nigerian universities, especially as this particular incident concerns the Niger Delta region directly. Chief Andre Emwanta joins us virtually. Thank you very much for joining us.
Yeah, thank you for having me, Xavier. Good morning or good
Good
afternoon.
afternoon to you. How's Abuja?
I think Abuja looks a bit bright. The Hamatan wind is gradually coming.
Well, that's good. It's almost as if the rains will not cease.
I think the effects of global warming make it difficult to tell when is Hamatan in the south, but in the north, it's here already.
Indeed. Well, I mean, talking about global warming, I don't know what kind of warming this is morally. When we talk about abuse of office, a person that highly placed in the university system, and this is just one case out of many that may still be in the system going undetected. When you look at the tenets of this particular ruling and what has been the outcome of it, do you see a significance that stands out or any glimpse of hope it holds for the Nigerian university system?
Yeah, thank you, Xavier. Being your guest this afternoon, makes me somebody who history has placed. And I think it's a coincidence that I'm the one to talk about a topic as significant as the judgment delivered by the Federal High Court this Monday. Professor Ndifon, coincidentally, was my colleague. His office was directly opposite mine in the University of Calabar. And I'm talking of a situation that lasted or spanned a period of 20 years. I mean, we've had allegations of this kind that lasted for 20 solid years, period of 2 decades. And the investigation itself started since September 2015. So that by the time he was convicted this week, it was for a period of 10 years that he was not just under investigation, but that the system itself condoned such an anomaly, because it was not just him that was on trial. I think it was our criminal justice system that was on trial. It was professional ethics in our average house that was on trial. And also, it was the rule of law that was on trial. So for me, it assures every human being who calls himself a Nigerian citizen that the judiciary is the last hope of the common man. Because those victims of sexual assault, of sexual harassment, that endure these 20 years emotional torture, I think with that conviction of Monday, it has given them some form of hope, a glimmer of hope, that there's rule of law in Nigeria, and the word justice exists not just in our statute books, but in reality. And I want to avert my mind to the definition of justice. A great legal man, jurist, Supreme Court judge, Justice Chukwudufu Oputa, said in the much celebrated Nigerian case of Josiah and the State. And I quote him, he said, "Justice is not a one-way traffic, but a three-way traffic. Justice for the accused, justice for the victim, and justice for the society at large." So that on Monday, all the victims, not just the people reported, and I must commend the judge for not disclosing the identity of the principal witness, who the culprit, in return for admission, asked for her virginity. That was the same kind of harassment. Female students, both diploma, undergraduate, and postgraduate students, were made to go through for 20 solid years. And if you ask me, it's a big problem, not just in the University of Calabar, but you have it across our ivory towers, particularly in public universities. And until we deal with this problem, education in Nigeria, particularly at the tertiary level, will be under serious threat.
All right, well...
And I think that's, maybe the reason why people prefer to send their children abroad
Chief Emwanta,
for university education.
Bring us some in-depth understanding as regards the ruling that led to the conviction of this professor for 5 years. What were those aspects that stood out? And of course, those areas that were really grilling that led to this conviction?
I think I will just quickly do a simple analogy. The first allegation that was made sometime in 2015, which was a clear case of rape. I will not mention the name of the student. He was able to get around it because the police report was not solid. It was not rock solid. And at that time, he made allegations of bias against the then ICPC chairman, who was from Akwa Ibom State, where the victim was from. And again, there were too many interferences. But thankfully, even much as, against all odds, against, what I'll call due process, a man who was accused of rape, and there were clear evidence that he actually raped that female student, was reinstated by a woman who became governing council chairman, a politician of that university. And unfortunately, colleagues in that faculty elected him again as their dean. So this thing continued until when recently, I think sometime in 2023, because the thing became so pervasive, that students of that law faculty openly protested. And I must commend it then, I think she's still the VC there, the Vice Chancellor, Professor Banku Obi, who listened to their cries. And when they did preliminary investigation, there was a prima facie case against him. So he was suspended as dean, and the ICPC now swooped in. And we must commend the ICPC. It was a long walk for them. But when you look at the judgment, from the facts before the court, it was not just a case of rape that was brought against him, but I think the ICPC here was a bit strategic because they don't have a clear mandate to investigate and prosecute for rape, but they looked at, the Cyber Crimes, Act, and under the Cyber Crimes Act, when you demand for obscene or nude photos, it constitutes a criminal offense, because Ndifon, in that particular case, actually requested for that particular fellow student, labeled TKJ, to send her nudes when she now refused to give him his virginity, because it was a case of virginity for admission. She was to cross from diploma in law program to the degree, so him now made that a condition. And unfortunately, because she refused after several attempts at physically, having, sex with her in his office, I think there was a time she went to Enugu and now requested for those photographs. So that was one of the evidence that the ICPC used in preferring that charge. And also, you also had that part of abuse of office, because as a university lecturer, you occupy an in loco parentis position, particularly as a dean of the faculty. As a father of the faculty, it was your duty to protect that student. But rather, you were now asking her to exchange her virginity for admission. So that was abuse of office. So it was on those two counts he was convicted. Mind you, he was just the first defendant. The second defendant was his former student, who, of course, a lawyer, one Anyanwu. And I think they were trying to compound the offense he committed. They were trying to discourage that fellow student from assisting the ICPC. They were even making threats. But I think the court said there was no strong evidence to convict.
Yes, I was going to take you to the
walk to justice, and
I was going to take you to the issue of the Sonny Anyanwu, that's Ndifon's co-defendant, who was discharged and acquitted by the court because the prosecution couldn't link him to counts 3 and 4. Now, what are those legal lessons from that, particularly around the duty of defense lawyers, and what counts as interfering with justice?
I think the legal lesson is that no matter how hard you try to truncate the course of justice, the law itself has certain statutory safeguards, because compounding itself is a criminal offense under a criminal code and, of course, under the ICPC Act. And it now says that in the future, even as a lecturer, you cannot, in the spirit of solidarity, threaten any student who has raised allegations or made allegations of rape, because the moment you do that, you become an accessory after the fact. And of course, you can also be convicted for the same offense. So I think it's a lesson for those who support rape. Sexual harassment. And I must quickly say that the problem we have is not just sexual harassment, but sexual harassment has a twin sister, which is exam malpractice. And I'll quickly say this. Ndifon had a modus operandi. When I came in as a lecturer in the law faculty in 2012, I caught a student cheating. Because at that time he was the acting dean, I took the phone I found with the student to him. But what did he do? The student later informed me that he slept with her and returned the phone. So you find that he uses that as a tool, because this particular student he raped in 2015, he made an allegation against her that she was involved in examination malpractice, invited her to his office, and raped her after tearing her script. So you find that until we deal with this hybrid-headed monster of sexual harassment on the one hand and examination malpractice on the other, we will just be deceiving ourselves. It's a very big problem.
Well,
so any bill on sexual harassment must have that component of exam malpractice. And exam malpractice, we have limited it to just cheating of students in the exam hall. How about lecturers that change marks? Because that was what Ndifon was known for. That was his stock in trade, of changing grades. For those students in the diploma program, somebody that failed, they will change their grades. The person will have a distinction or an upper credit. Nothing demoralizes other students more than that. It's a big problem in our educational system. Until we solve this problem, our leadership question will remain on the balance, because these are the people who churn out as judges. These are the people who churn out as senior advocates. So what do you expect? It's garbage in, garbage out. So I think there's need for the president to declare a state of emergency in the educational sector and deal with this problem through legislative intervention.
Indeed. Well, this case isn't just about one professor now, as you have rightly put it. It raises questions about how universities guard against abuse. From a legal reform perspective, what policies should universities like UNICAL and indeed others across the nation adopt to make sexual harassment complaints more transparent, fair, and safe for students? Because, most of the students, you'd see them not being able to come forward with information of this nature. What could be the problem? They seem to be operating in fear. Nobody seems to speak up, but these issues are there.
I think the judgment of Monday reinforces faith and confidence in the system. And I think we must also consider what I'll call the systemic enablers of examination malpractice and this problem of sexual harassment. And I think I will be able to identify three. First is this problem of ethnicity, because we have what we call tribal solidarity. The two major victims of Ndifon I know are not cross-variants. So most of his victims are usually non-indigenous. And funny enough, his people will normally solidarize with him. And that is what builds impunity. Then you also have this problem of cultism. As a law faculty lecturer, I know there was a time he even invited me to one of their confraternity meetings. And I told him that you don't do this. Without my consent, you cannot invite me to a group I don't want to be part of. And you find that we've had previous vice chancellors that didn't take any step. But Professor Banko, who is not a member of his confraternity, insisted that the writing should be done. And we also have, tied to that is the problem of weak institutional leadership, because we have a female VC who insisted that the writing should be done. That was how he was brought to justice. The judge that gave that judgment, beautiful decision. The present leadership of the ICPC insisted that this matter must be prosecuted to completion. So we must thank all these people, lecturers in the law faculty, one barrister, Anagi, Barrister Ibo, who started the advocacy. So a whole lot of people have been able to come together to insist that we must change our system. But again, you have the sexual harassment bill that has been in the National Assembly since this incident took place. The first victim of Ndifon in 2015, just recently the House of Reps have passed it. So we expect the Nigerian Senate, to pass the bill in the present state. But at the same time, I think our examination malpractice laws should be reviewed. We must make it a criminal offense for lecturers to change grades in Nigeria, because that is what they use as a tool for sexual harassment. So I think there must be what I'll call a total overhaul of all laws on exam malpractice, sexual harassment, in a way that we don't create room for technicalities. One of the technicalities in different ways was that, the forensic examination of the phones and everything was supposed to be brought before the office of the National Security Advisor. Of course, the judge did not agree with that argument, because that is what the cyber crimes laws say. So for us, we must take away most technicalities that exist in our laws and make it the way the Edo State anti-courtism law is, where you have death penalty. I think when offenses like this attract 21 years imprisonment, nobody will be told to stop either harassing students or allowing students to be involved in malpractice or changing grades. So I think it's a very big problem. And the only way we can deal with leadership as we have it in Nigeria is when we go back to our ivory towers and have a total reform. So I think there's need for all stakeholders to come together, and the president must declare a state of emergency in tertiary educational sector so that we can give our university students a safe environment to learn and become what they want to be.
Well, Chief Emwanta, I'd like to know how this addresses the issue of fear among students who may have been victimized one way or the other as a result of these harassments. How do we identify the issue of fear and persons who have something to say but are simply scared of what the system could do to them if they were to come forward? Are there creative ways of getting out information, say a student had complaints to make regarding issues of this nature?
I think the reason why the ICPC have what they call the Anti-Corruption and Transparency Unit, that's the ACTU, is for this same reason, so that you can even have whistleblowers, and the courts also try to have these victims protection units, as they did in this particular case where they labeled the particular students. But again, we live in a society where nothing is hidden. So I think it is for the National Assembly, I think the Nigerian Senate, because the bill has gone to the Nigerian Senate, to create such institutional safeguards. And beyond that, it's a leadership thing, our leadership selection process. Because when you have people of integrity as vice chancellors who do the right thing, and beyond that, I feel that security agencies like the police and others who have in the past compromised should not be allowed to handle cases of this kind. And again, I think the Nigerian government must organize a special confab, on tertiary education in view of this decision, so that these issues can be addressed and certain far-reaching decisions made. Until we do that, we'll just be deceiving ourselves, because it's 1 out of 1,000. We have many Ndifons across our university system. Until real action is taken, I don't expect, us to have a complete departure from what.
All right, Chief Emwanta, I would let you go, but just one last question regarding this particular issue. How can universities now design reporting mechanisms that I believe would legally be robust enough and be student-friendly, of course, so that victims can report without fear of retaliation or stigma within the university system? Is that possible, or is that compromised even? You talked earlier about cultism and how it has been deployed as a tool.
I think in Edo State, I'll use the Edo State example. The governor of Edo State decided to give cultism what I'll call a mortal blow. First, once you are involved in cultism and you have a property, we even have an amendment to that bill whereby such a property can be forfeited to the state. So you don't need to wait till the person is convicted. And of course, it attracts death penalty, so that if under the guise of, because you belong to a cult, you now sexually harass a female student and you rape her, you face the term. And as such, I think across the various states, this idea of people hiding under the cover, it does not matter the group, whether you call it a registered trustee, because people will argue that some of these cult groups are, corporate entities and whatever. But to understand the Edo State governor, there's a particular place called the international headquarters in Edo State. That property was demolished, so that there's a causal link between cultism, exam malpractice, and sexual harassment. So it still brings us back to this confab. And I propose that such a confab should take place almost immediately. Early next year, the present Minister of Education has that duty. The security agencies like the anti-graft agencies like the ICPC and others must come together to have this confab where we can deal holistically with this problem of sexual harassment. And people have even argued that we should not just limit this problem of sexual harassment to our tertiary institutions. You even have it in secondary schools. You have it in workplaces. So I think there's need for us to deal with this problem holistically. We have the Violence Against the Persons law. There's need for that law to be reviewed so that it can deal with this problem of sexual harassment, because it has become a problem. And we call them gender-based violence because it's usually targeted at female gender.
All right. Thank you very much, Chief Andrew Emwanta, constitutional lawyer and public affairs analyst, for speaking to us in Niger Delta today. And we're hoping that these points that you've raised would be put into consideration, especially towards ensuring that these issues are nipped in the bud. Thank you for speaking to us.
Thanks for having me.
All right, so that's the size of Niger Delta today. Thank you very much for watching. Catch you again tomorrow for another fresh edition, God willing. My name is Xavier Roberts, wishing you a terrific afternoon. Bye for now.